The plaintiff commenced this action to recover amounts due from defendant under the parties' commodity swap contract. By presenting proof of the contract and the defendant's failure to make payment according to its terms, plaintiff carried its burden as a summary judgment movant to demonstrate its prima facie entitlement to judgment as a matter of law. The defendant, however, failed to meet its consequent burden to raise a triable issue warranting the motion's denial. Contrary to the defendant's argument, the parties' contract was not an illegal contract to gamble, but rather a legitimate commodity swap agreement exempt from the strictures of the Commodity Exchange Act. Nor were defendant's contract obligations excusable as impossible to perform. The defendant's performance may have been ordered and financially disadvantageous to him by circumstances unforeseen by the parties at the time of the contract's making. However, financial disadvantage to either of the contracting parties was not only foreseeable, but was contemplated by the contract. In any event, it is not a basis for reliance upon the impossibility of performance doctrine. The force majeure doctrine is no more helpful to defendant. The parties' integrated agreement contained no force majeure provision, but less one specifying the occurrence that defendant would now have treated as a force majeure, and accordingly there is no basis for a force majeure defense, nor is there any basis for a frustration of purpose defense. The inducing circumstance for the subject contract was prospective instability in the price of cobalt, the commodity swapped under the contract. The plaintiff sought to insulate itself from cobalt price increases by shifting the risk of such increases to the defendant, and the defendant in exchange sought to shift the risk of cobalt price decreases to plaintiff. That the price of cobalt increased due to market forces did not frustrate the contract's purpose. To the contrary, it constituted an instance of the very market instability whose prospect induced the contract in the first instance. Also, without merit is defendant's claim that the parties' agreement was orally modified to relieve defendant of the risk of cobalt price increases attributable to labor strikes. While oral amendment is not barred under the agreement, the evidence of the purported oral agreement offered by defendant is insufficient to raise a triable issue as to whether a sufficiently definite agreement was entered into. The evidence in the record indicates, at most, an agreement to agree, which is not enforceable. Contrary to the defendant's arguments, the special referee's calculation of damages was proper and in accordance with the court's reference. The defendant is not entitled to damages allegedly sustained by reason of the July 6, 1999 restraining order, subsequently acknowledged by the motion court to have been improperly issued. The defendant's sole remedy under the circumstances presented, in which there is no sustainable claim that the application for the restraint was maliciously motivated, would have been to proceed against any undertaking posted as a condition of the restraining order. However, no undertaking was posted by the plaintiff, and the issue of whether one should have been required is now academic, the restraint having been vacated. Finally, the document discovery afforded plaintiff in aid of his discovery or recovery of the contract damages to which it established an entitlement was proper, as was the court's grant of permission to plaintiff to serve a post-judgment subpoena upon a person alleged by plaintiff to be one of defendant's managing officers by serving the subpoena upon the defendant's New York attorney. We have reviewed the defendant's remaining arguments and find them unavailing. Thus, we find for the party in favor of the, for instance, C. Coutts Bank Switzerland Limited versus Anastasio, 275, Appellate Division 2nd, 609, 611, 713, New York Supplement 2nd, 45, Sullivan, Judge concurring.